Okay, let's continue with the second part of maintenance. Okay, that is the maintenance for the wife after divorce. Under Section 77 of the Law Reform Marriage and Divorce Act 1976, it states that the court may order a man to pay maintenance to his former wife. Okay, as what has been laid down in the case of Li Yulan and Lim Tian Chi, where the court state that an unemployed husband could be legally ordered to pay a nominal sum for his spouse or ex-spouse and his children. Section 78 of the LRA provides for the assessment of maintenance, which will be based on means and needs of party. It provides that the assessment of the amount of maintenance it is based primarily on the means and needs of the party, regardless of the income of the husband or wife. Section 80 of the LRA talk about compounding of maintenance by the making of lump sum payment at once. Okay, the compounding of maintenance actually originated from the common law principle of clean break, where the court used the presumption that if the marriage ends, no ongoing obligation to the wife. Based on Section 81 of the LRA, the maintenance order will expire first if the maintenance was unsecured on the death of the husband or wife, whichever is the earlier, or second, if the maintenance was secured on the death of the spouse in whose favor it was made. The order of maintenance will also cease if the wife living in adultery or remarry, as has been provided for under Section 82 of LRA. Section 83 of LRA provides that the court may vary or resign order for maintenance on the application of the person in whose favor or of the person against whom the order was made. The variation of rescission can be made on the following reason. First, the order was based on any misrepresentation or mistake of fact, or where there have been any material changes in the circumstances. Okay, in the case of Liu Koi-Wah and Ng Kok San Phillips, the court held that in assessing the amount of maintenance, the court should base its assessment primarily on the means and need of the party. In Koh Cheng-En and Linda Herawati Santoso, in deciding the amount of maintenance that should be paid by the husband, the court regarded the duration of the marriage, whether there were any children of the marriage, the age of the party, whether the husband had financially supported the wife during their marriage, the party earning capability, and whether the divorce would have been affected the husband's position financially. Okay, and in Chow Ah Nui and Tan Kim Chai, the issue of fair and reasonable maintenance must be determined by reference to the fact and circumstances of each case. The court took into account the devotion of the wife, the husband's financial need, the standard of living of the wife, and the means and the needs of the party. The court shall consider who caused the breakdown of marriage and shall penalize him or her through the order of maintenance. Okay, the degree of responsibility which the apportion to each party for the breakdown of marriage, if the other party to the marriage caused the breakdown of the marriage, the amount for maintenance would be affected, as has been decided in the case of Li Yulan and Li Tan Chi, where in this case the court looked into the account the responsibility on the part of the respondent husband for the breakdown of the marriage by arriving at an appropriate sum of maintenance. In Anna T. Siu Hong and Joseph Ng Tiong Yong, where the respondent had been paying Rm500 per month as a maintenance to his wife for many years, but he started to default in his payment. The respondent then filed an application for a rescission of the maintenance order, as he claimed that he was 60 years old, suffering from several ailments, and had no permanent work and was dependent on his second wife for financial support. The application was allowed by the court, as the court satisfied that there has been a material change in the circumstances. Okay, now let's proceed to the maintenance for children. Section 92 of LRA impose duty to the parents to maintain the children through, though not in his or her custody, either by providing them with such an accommodations, clothes, food, or education. Section 9 subsection 3 give power to the court to order maintenance for children not only against a father but also to the mothers having regard to her means she can do so. In the case of Liu Kuiwa and Ng Kok Seng Phillips, the court held that if both parents are earning, both of them are liable to maintain the children according to their means. And in Wong Kim Fong and Tau Ah Kan, the court ordered the mother to pay RM 400 while the father to pay RM 800 per month as the maintenance for their children. In Parkunan and Kalayarashi, where the judge did recognize the wife's obligation to support a child but maintains that it is only secondary to the husband's basic duty to provide child's maintenance. In this case, the court considered the capacity of the husband, his ability to pay, and the realities of the husband or the parties' financial positions when deciding on the quantum of maintenance. A child maintenance order shall expire on the attainment of the age of 18 or if the child is under physical or mental disability on the ceasing of the disability as has been provided for under section 95 of the LRA. In the case of Karunai Raja and Punitambigai, the issue before the court was whether the involuntary financial dependence of a child of the marriage for the purpose of pursuing and or completing tertiary educations in order to obtain a first degree came within the exception of financial or physical disability under section 95 of the LRA so as to entitle the child to maintenance beyond the age of 18 years. It was held that the respondent husband need not to continue pay the maintenance because the court follows strictly the intention of the Act. Whatever Act has decided, the court will not go to interpret further. The word disability only evoke to physical and mental disability, not to include financial disability. Therefore, the judgment was given on behalf of the respondents. And this case must be distinguished with the case of Chin Sing Wah and Lim Shuk Lin, where the father had to oath to his two daughters to pay maintenance until they completing tertiary education in order to obtain a first degree. In this case, the court held that even though the involuntary financial dependence of a child of the marriage for the purpose of pursuing and or completing tertiary education in order to obtain a first degree does not come within the exception of physical disability under section 95 of LRA, but the father has moral obligation to fulfill his promise made to his daughter. Therefore, the father must continue pay maintenance regardless the child have attained beyond the age of 18 years old. Now, let's proceed to the enforcement of maintenance order. The Act which is applicable for the enforcement of maintenance order is Married Women and Children Enforcement of Maintenance Act 1968. Section 2 of this Act provides that this Act should be applicable to the state of Malaya only, meaning that to the Peninsula Malaysia only. And Section 4 give the court the power to make an attachment of earning under which will be serving on the defendant employer. Section 7 of this Act provides that a person to whom an attachment of earning order is directed must comply with this order, and any person who fails to comply with the order shall be liable, upon conviction, may be imprisoned for not more than 1 year or a fine not exceeding 1,000, or both has been provided for under Section 12. Okay, with regard to the areas of maintenance, there is no specific provision in the LRA relating to this matter. However, Section 3, Subsection 3 of Married Women and Children Maintenance Act provides that maintenance shall be payable from the date of neglect or refusal to maintain or from such a date as may be specific in the order. But according to the principle laid down in the English case of LASCOM and LASCOM, in this case the principle is that the area of maintenance cannot be enforcing for more than 1 year, and this principle has been accepted into Malaysian court. Under Section 86 of LRA, which it provides that the area of maintenance shall be recoverable as a debt from the defaulter. And in the case of Amrit Lal and Sobayawati, the appellate court held that the trial judge had failed to consider the practice as laid down in the case of LASCOM and LASCOM, where under this case, an order for maintenance for more than 1 year backward could not be enforced. And in the case of Ganggaharan and Satyabama, the appellants appeal against the decision of the Session Court order which give judgment in favor of the respondent and order him to pay the sum of Rm 7,200 for areas of maintenance. The appellant argued that the court had no jurisdiction to award areas for more than 1 year, and the court held that the order for areas was allowable only for a period of 1 year. And Section 98 of LRA provides for the recovery of areas of maintenance of the child is same with the recovery of areas of maintenance for the wife under Section 86 of LRA. That's all. Thank you.